This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight we're taking your calls and questions about law in the new year. So happy holidays. Glad we've gotten through it. Now everybody's focused on the new year, New Year's resolutions, maybe some tidying, some decluttering, and let's talk about some things your legal new year. We'll talk about some laws that are changing. We'll also talk about some things you should not put off. Many people put off writing a will. Many people put off updating insurance policies. How do you know if it's too late to file a claim? What kind of guidelines, what kind of deadlines do you need to be considering? And will some new laws take effect and affect you this year? Call in your questions, the 31 Law Call number, 256-536-0077. You can also email your questions. You can email a legal question on any legal topic any day of the week. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we'll pull some of those out. We've got some of your email questions tonight. We've got with us tonight Will League and William Meservey from Timberlake and League, and we've got our video. Happy New Year, everybody.
Happy New Year.
All right.
We've got some video we like to let you make the law call. We pulled some video off of YouTube, something that's got a legal basis to it. Okay, we're used to security guards that are supposed to enforce rules and things, but when they go too far, what happens? Is he the security guard? If this guy is really injured, is the security guard in trouble financially? Is his employer going to be in trouble? When you're looking at this as personal injury attorneys, what are you thinking about?
You know, William and I we looked at it before the show, and so William and I, we had a little bit of a disagreement on different angles. Okay. William, what's your thought first? I'll set you up. Now let me see if I can.
All right, that'll work. My thought is, you know, at the very least, this is going to be an intentional tort of battery, right? And we don't talk about intentional torts as much as we talk about negligence and some of these other things. But you know, assault and battery is not just a criminal charge; it can also be a civil claim. And now they're not typically brought because they're not typically covered by insurance. An intentional act is typically not going to be covered by insurance. But what that means is that it doesn't mean that the individual doesn't have a case. It simply means that they're going to be pursuing, you know, possibly the personal assets of the security guard and or of the company if they negligently hired or something along those lines.
Well, so my thought is, okay, so let's say, I don't know if he was an officer of the law or if he was a security guard.
Right.
So, I couldn't really tell. So let's say kids out there skateboarding and not supposed to be, and he's an officer of the law, you know, he has those powers. Can he use reasonable force, you know, William, can he use reasonable force to stop that conduct? And it's put his, it was kind of funny, I'm sorry to say, I hope he's not hurt, but you know, so he steps his foot out, he stops the skateboard, and the kid just, you know, goes flying.
He stopped a crime. You're saying he stopped a crime.
So in Alabama, unfortunately, because it was uncool, you shouldn't, you know, if he's going for it, might let him, you know, let's do it another way. But if he's breaking the law, under Alabama law, if he's contributory negligent, doing something he knew he shouldn't have done, he's violating the law, and he is technically at fault, that might get him. Although the cop did touch him, and he's not allowed to, so where's it going to fall on that?
I do think it makes it a pretty, there is going to be a distinction there if it's a police officer versus simply a security guard, right? Because in those type situations, security guard really, you know, if someone's not listening to them, they're typically going to call the police, right? To have the individual trespass from the property.
Right.
But it does make a difference if it's a police officer. I'm with Will on that.
So yeah, it'd be interesting. I mean, he may have a claim. He may be breaking the law. He went flying, that's for sure.
Glad it's not worse than it was. I mean, this could have been something even higher. It didn't look good, but it could have been something even worse.
That's right.
So, New Year. Let's talk a little bit about statutes of limitations. So, as you watch dates tick by, that means something for a case like this or any case. What are you thinking when you watch time pass?
Well, every year comes, we talked about, you know, law for the new year. What does that mean? You're updating insurance policies. You're looking at, you know, uninsured motorist coverage. Have you prepared your will? Do you have a living will if you're incapacitated? You know, and a lot of people call our office, say, hey, it's the new year, we're getting things together. I'm signing up for this new automobile insurance. What is UM? Do I need it? And we hear all the time that only pay for what you need, tailor your insurance. Well, that's really a way to get them out of trouble if you need that type of coverage. So all those things come on at the new of the, at the first part of the year, and statute of limitations is anything else, but it's any time. 2 years from the date of the injury, typically in Alabama. If it's contract, it's 6 years, or punitive damages, it can be 6 years. Now some of these cases under contract, let's say it's a nursing home, a lot of these people go in and they are signed in by their loved ones. And we talk about arbitration and mediation. There's these mandatory arbitration clauses in nursing home contracts, which precludes, some of your rights. William, we're seeing more and more nursing home cases, nursing home neglect. Usually it comes down to poor staffing, but in terms of statute of limitations, what's the difference? Is that a medical malpractice situation?
It's generally going to be a medical malpractice situation. Now, that doesn't necessarily change your statute of limitations. You're generally still going to have your 2-year statute of limitations for the state of Alabama. And whether or not an arbitration agreement is enforceable is going to depend on the mental status of the individual when they enter the home. If they signed themselves, if you have an altered mental status, you're going to have an argument that that arbitration agreement's not binding because the individual didn't have mental capacity to appreciate what they were doing. And that's one of the things that people should also be evaluating this new year that we don't talk about as much as we talk about wills is power of attorney. You have to give power of attorney to a loved one or a trusted one while you still have the mental capacity to do so. And too often we find that, we get calls to our office and, hey, I need a power of attorney, mom's got dementia now. Well, at that point, it's too late, right? So at that point, you're having to go through the probate court and establish a guardianship and do all these different things. So another thing for folks to look at during this time of year would be, if you're getting to be your health's declining, or you're starting to, lose some of that mental capacity, before it's too late, go ahead and give power of attorney to a loved one.
And how does that affect it? People are talking at Christmas and New Year's, and you're with family when you're talking about a power of attorney for your life, or if you have a will, there's usually someone named as personal representative. So William and I handle, personal injury, death cases, and things like that. Let's say this person perished without a will, and then there is no personal representative to maintain that action on behalf of the deceased. So even after you perish, there's reasons why you have a personal representative named, and you could go to the probate court and have one named by the county or named a county administrator. However, you want to look at all the aspects of your particular state and make sure it's covered while you're here and for your loved ones, once you pass.
Maybe that you saw somebody over the holidays and you realize they're getting on in age, and it may be a reminder to take care of some of those things.
Could be.
We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight? Hey, Howie, are you with us? Howie from Huntsville, what's your question tonight?
I bought a property at a sheriff's sale and had a 1-year statute of limitation to redeem it. And the people I bought it from, they filed suit against me to get the property back just within a year, but they didn't ask for redemption, and the case is still pending. Can they change that to make it, even though the statute of limitation is passed, can they change the suit that's already been filed to make it within the statute of limitation?
All right, here we go.
Yeah.
All right, so the sheriff's auctioning off the property on the courthouse steps, you buy it, right?
I think that was right.
Well, I can't hear you.
Okay, sorry. So you buy it. So that gives, let's say they fail to pay their taxes. That gives you a year. If they don't pay the taxes within that year, then you get that property. And you're saying they filed suit before a year was up or after a year was up?
I think he said
I think within the year, but he's thinking that they didn't do everything, they didn't list everything in the complaint that they
and
needed
then
to.
they changed it after the statute.
Can you amend something like that?
Well, so you got to go by the procedure. So there may be a procedural bar, just like any case. You got to comply with the statute of limitations we were talking about earlier, the time limits, all those things. Now, unless there's a reasonable exception or excuse under the law, then even if they didn't file whatever they're supposed to file, then you would win. Now, even if the case is still pending, you should win if they fail to follow the procedure, unless the judge determines there's some type of excusable neglect. You'll have to go to case law and see what that is. So I would sit down with a real estate probate attorney and see if you can get the answer to that, and just to make sure that all the procedures were exactly followed.
Let's talk a little bit about amending complaints and things, because this comes up with you guys, comes up with my cases. many times you are able to amend a complaint, right? To fix something or you learn something as the case moves on. Talk about that.
It's not uncommon at all for complaints to be amended. Once you file a complaint, you're going to immediately move into what we call the discovery phase of a lawsuit. And that's where you get to send to the other side written questions and request documents from them. They get to do the same for you. So, based off what you receive in that discovery, that may change what your theories are. So it's not uncommon for both the plaintiff to amend and for the defendant, because the defendant may receive his discovery responses and say, hey, look, I've identified here an affirmative defense that I didn't initially see in this case. So, but really pretty common.
That's exactly right. I mean, you see the cases evolve. Once you start taking depositions, you get more information. Sometimes theories present themselves that you didn't have all that to fairly and accurately plead that in the original complaint. And so usually you can amend freely unless you're a certain amount of time up until trial, and then you may have to have leave or permission from the court.
Mm-hmm. Now, in a medical malpractice setting, you've got some heightened pleading requirements, right? So in that type scenario, you've got to be a little more on point when you're filing your case versus just a typical negligence case where you're not going to have those heightened pleading standards, and the court's going to be a lot more lenient with you in that scenario.
Interesting. We've got Remy on the line with a question from Florence. Hi, Remy. Thanks for calling. What's your question tonight?
Hi, Happy New Year, Sharon.
Happy
New
New
Year,
Year.
Will.
Happy New Year.
My question, I had a lawsuit against me by my half-sister. I'd lent her some money, and she didn't pay me back, so I posted it online, and so she sued me for libel. And so, anyways, went to court, and I got a judgment against her for like $30,000 because she owed me 10 plus the lawyer's fees and all that, and the judge said the interest is like 6%. That was in 2016. So she lived in Texas, and I lived in Arkansas, which is where the court proceeding took place. So anyways, I had posted down there to get somebody to help me recover that, and I had got this guy that said he was a PI with this law firm. So they sent a contract up stating that they would get, it was like 60-40. And so I had my lawyer there in Arkansas look it over, and she said, yeah, everything's copacetic. Sent it back down there, and then never heard anything from him. So I contacted the PI, and he said, oh, we went through her garbage. She doesn't own anything. She leases cars, this, that, and the other. And I never heard anything back. So my question is this. He's long, the PI's long since gone. The lawyer, the law firm that was listed on the contract, they're not there at that address anymore. I want to know, did anybody collect that judgment down there in Texas, and I didn't get my share? I have no idea.
Did you pay him any money to do it?
I didn't pay him a dime. It
was going to be on contingency. Yeah.
Right.
Right. But
That's interesting.
Collected or not?
Yeah, I think most lawyers would tell you that they've got a drawer full of judgments that if they could collect, they could retire. Oftentimes in a situation where no insurance is involved, like this one, getting the judgment isn't necessarily the difficult part of that case. It's going to be collecting that judgment. And if someone's living paycheck to paycheck and doesn't have any assets, like the vast majority or a great deal, the majority of Americans are these days, then you're going to have a really hard time ever collecting any of that money unless you're following this person around, filing with the courts to garnish wages, which means you have to know where they're working. It can be extremely difficult, and you have to, kind of stay on that. So there are some law firms and collection agencies that do, focus on that. But if what the PI showed was that, look, here's a person that has no assets, they're, living paycheck to paycheck on minimum wage, they may have looked at it and said, hey, look, what it's going to try to cost us to pursue this particular judgment and make a collection here just isn't going to pan out. So it would matter if the person has assets or if they don't.
And you sign a contingency fee basis contract, which means they get a percentage if they recover. William and I, personal injury attorneys like us, we work on what's called contingency fee basis, which we don't get paid until we win your case. You hire these guys based on a percentage, And if they were to recover, then they would have been entitled to X%, whatever you guys contracted upon. Now, some of the procedures, you get that judgment. Sounds like she sued you, you filed a counterclaim against her, got a judgment. What you want to do is preserve that judgment and file that with the probate court and keep that in Alabama. It lasts for 10 years and you have to refile it. Now, you contacted the PI, you contacted the firm down there that was going to investigate, and if they found that she didn't have any assets, she's leasing cars, things like you just said, then William's exactly right. There's nothing to get. You want to preserve your claim through the probate court, so if something happens, she wins the lottery, then you can collect on that particular judgment, but you have to stay, you have to stay on it. And it's your sister, so I hope you know where she is.
Yeah.
Right?
Half sister. I think.
Okay, yeah, right.
We're going to take a break. Be right back answering more of your questions in Law in the New Year. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Joviet. With me are Will League and William Meservey, both from Timberlake and League, answering questions about law and the new year, and we've got callers waiting. Judy's on the line with a question from Athens. Hi, Judy. Thanks for calling. What's your question tonight?
Yes. How do you go about someone taking advantage of an elderly lady?
Okay. Can you give, is
Any
it like
more
physical
details?
abuse or are they taking money or what is
Money.
it? Money. Okay.
There's several aspects. There's a criminal aspect of it, and there's a civil aspect of it. Oftentimes we see cases where some, families will set up nanny cams in their loved one's nursing home room, and we've had cases where there's some thefts going on and things like that. The first line I would tell people is let the police handle it. It's a criminal activity. And then the investigator will come out and investigate that particular case, see what evidence you have, see if it's enough to bring an indictment, arrest, any of those things in that realm. If that is proven, that's beyond a reasonable doubt in the criminal side. So what William and I do is on the civil side. So William, on the civil side, it's not a reasonable doubt, but beyond a reasonable doubt like you hear on TV.
Yep, but you still bear the burden of proof.
Right.
And it's by a preponderance of the evidence, which means more likely than not. So in the example Will's giving you in a criminal setting where you have beyond reasonable doubt to a moral certitude, the scales of justice are doing this. It's got to be 100% what the state or the city has to prove, or the county. But in a civil setting, the scales of justice have to do this, right? So it's a easier burden to meet, but at the same time, the penalties are different.
Right.
So we're pursuing monetary damages versus trying to put someone in prison.
A lot of times, somebody who's stealing money, if you get a judgment against them, can they pay that back? Is it collectible? Things like that. Another scenario that we see is, grandpa's getting a little older. All of a sudden, his new best friend from across the street has a new will, and now he's power of attorney, and he's also personal representative, and he's misappropriating the funds in that regard, and depleting the assets. Again, you want to have an accounting, have your family accountant, contact an investigator, and still go through the same processes, but you see more orchestrated abuse than we used to. William, so somebody came in a couple of years ago and they had X amount in their estate. All of a sudden his new girlfriend is paying all of her friends or whatnot, and we tried to get that money back, but it wasn't there because
it's gone.
It was gone.
Right, yeah, and they've spent it. And there's other resources available as well. There's TARCOG, the North Alabama Regional Council on the Aging, and you've seen the state put forward a lot more resources from the AG's office, the Attorney General's office, on countering these scams, which are targeting, kind of the boomer generation, the elderly folks now, because the scams have become a billion-dollar industry, stealing money from folks.
Yeah. That's right.
Let's talk a little bit about a new law, the cell phone law around the area. What has changed this new year?
Right.
What do we need to watch for?
January 1st, within the city of Huntsville, it's a good law. Let's keep people safe. I see a lot more. What used to be just a small rear ender, people down in their phones, dug in. Next thing you know, they auger in significant impact. And on the motorcycle wreck cases, those they're deaths.
Yeah.
And so it's so distracting, and it's causing so much mayhem. And so in Huntsville, which is a good law, you cannot hold your cell phone. It has to be set down. And so how do you prove that?
Yeah.
Officers can see that. It can be a reason to stop, a reason to search your vehicle, and can lead to other issues. Now, when we have cases when we're looking at cell phone data to see if you're on your phone, we'll bring experts they can tell us whether or not the phone is in a stationary position. Is it up? Is it horizontal? Is it down? When did the longitude and latitude, when did the phone stop? So there's all kinds of data, if it goes further, that they can get from your phone to determine whether or not it was being held. Getting crazy, I know, but they can prove it.
Wow, that's a big change.
Yeah.
We've got Mary Ann on the line with a question from Huntsville. Hi, Mary Ann. Thanks for calling. What's your question tonight?
Yes, I had some work done on my house,
Okay.
and it's not completed. And what it is, I don't know if you people have heard this in Huntsville, but they call it the draws. These people, they come in and do the work, and then they get the big one done and leave the last one, which is normally small.
Gotcha.
And then and I keep asking for receipts. They will not give me receipts. And this company was recommended by my real estate agent, so I'm really upset.
So if they haven't done the work, what can she do? Have you already paid them? You've already paid them a whole bunch of money?
No, not a whole bunch, but enough.
So
Yeah, right.
It matters if you, on the front end of this, get a good contract in place where you're imposing some timelines and different things like that. A lot of times what we see in those types of cases is that the contractor argues, well, I never gave them a time that I would finish it by. And, it's not that I've run off from the job, I just haven't completed it yet. And we're working on it, and we hope to get that scheduled soon, and we'll try to be down there to help little whoever. So, it is a tough type of case.
And we are seeing cases where foundation companies, they'll come in, little old lady, hey, you know what, you need $80,000 on your house, and let me put these things in, and this, that, and the other, and don't, so we're seeing some fraud out there. So be careful. Sounds like she was a victim of it as well. Like William said, have a contract, protect yourself.
We'll be right back. If you didn't get your questions answered tonight, here's how to get in touch with Will League and William Meservey. They are with Timberlake and League in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And for divorce, child custody, our own Sharon Doviat, SharonFamilyLaw.com, 539-7337.
The last caller was talking about something you said, the Better Business Bureau might be.
So, if the contractor is a member of the Better Business Bureau, you would be able to reach out to the Better Business Bureau. They provide a free arbitration service for their members. So that would be a potential way to resolve that dispute without having to incur a lot of the cost of litigation.
Thanks for your calls and questions tonight. We'll see you next week.
Good night.